orchestrating the 1996 killing of rapper Tupac Shakur got underway today in a Las Vegas courtroom. The trial comes decades after the rapper was gunned down in a drive-by shooting near the Strip.
KTLA's Kimberly Chang has details on today's opening statements.
Hi, both prosecutors and the defense made opening statements today, and witnesses took the stand on day one of the Tupac Shakur murder trial, taking place nearly 30 years after his death. Prosecutors say Dwayne Keefe D. Davis, a former gang member, was the mastermind behind a drive-by shooting that killed Tupac Shakur back in 1996 near the Las Vegas Strip. Tupac, a Grammy-nominated rapper, was 25 years old and his career was soaring when he was killed. Prosecutors told jurors that Davis confessed to his involvement in a public interview and in his book Compton Street Legend, where he provides first-hand details of the shooting.
And what you'll notice, a constant thing that always goes through these statements, is Dwayne Davis's visceral anger at Tupac Shakur for putting hands on his nephew. In the book, he says, "Them jumping on my nephew gave us the ultimate green light to do something to their."
Prosecutors labeled it a revenge killing. Tupac was in Vegas that night for a Mike Tyson fight. He and his entourage were involved in a fight with Davis' nephew, Orlando Anderson, hours before the shooting.
He got the gun. He was in the white Cadillac, and he handed the gun to the sheriff.
During opening statements, a defense attorney told the jury that the book is fictionalized and said Davis co-wrote it to make money.
What facts do you have to support any of what KPD said or any of his interviews are in the book?
Reporting in News Center, Kimberly Chang, KTLA 5 News.
With more, we are joined by criminal defense attorney Lou Shapiro. Thanks for being with us, sir. It's been 30 years since Tupac was murdered. As this trial begins, how does that time jump impact the job of both sides trying the case?
Well, anytime the situation is such that a lot of time has gone by, it's usually a problem for the prosecution because they have the burden of proof. So the longer the time goes by, the less witnesses we have, the less evidence there is, the ability to test forensics is not in play. And of course, as we know here, that most of the witnesses of this incident are now deceased. So there right away, we see is a big problem for the prosecution in terms of burden of proof.
Well, okay, so let's get to the arguments. Davis, a former gang member from Compton, not accused of pulling the trigger, but prosecutors are working to establish motive for orchestrating the crime, revenge for a long-running hip-hop rivalry. Now, is that a strong opening or simply circumstantial?
Well, anytime a prosecution has a theory of violence or murder, they need to have motive. Why did this person do that? And the motive they have here is that a family member, a nephew of this individual on trial was messed with, was sought after by Tupac. So this was sort of a revenge type situation. But again, motive alone is not enough to convict. There needs to be supportive evidence that even though this person may have wanted some sort of revenge, what's to prove that he and the people with him carried this out? That's where the prosecution is going to have the most challenge in this case.
The prosecution is relying significantly on statements from Davis himself. We know interviews, his own memoir linking him to the killing, but the defense is trying to make the argument Davis is prone to embellishing, lying, even as a display showed in court today. BS. What do you make of the strategy, the defense saying their own client can't be trusted? Is this to sow reasonable doubt?
So I would say 10 years ago, maybe the prosecution would have a better case. But these days, we're so used to hearing the term fake news that there's so much misleading information on social media platforms, on what we read, what we see. So for the defense to try to get the jury to warm up to the idea that just because something was written down doesn't mean it's true, I think jurors can relate to that to these days. And therefore, I think the defense does have a good shot on this one.
Okay, so the defense also calling on jurors to focus on facts, suggesting that the investigation was sloppy and incomplete. Is that a stronger case, given how little we know about this case 30 years onward? And could it work?
Yeah, it definitely can help. Again, because the prosecution has the burden of proof, it has to be beyond a reasonable doubt. And if there is a sloppy investigation or the evidence does not back up the motive, that it's just a story sort of being told by the prosecutor, you can almost see the defense closing argument that they're trying to convict my client based on a story, but at the same time, they're just telling you a story. So stories alone do not render convictions. There needs to be proof, evidence, forensic, witness testimony, eyewitness testimony. If that's not there, you can't convict my client. That's what I expect will be the argument.
All right, Lou, let's pivot from Tupac to Nick Reiner. A judge, as you know, delaying ruling whether or not Nick Reiner could receive his $1.5 million trust today. Access to that money could be pivotal in his case, as it will likely decide who represents him on the criminal charges he's facing for the deaths of his parents, Rob and Michelle Reiner. His attorneys say Reiner's legal fees are already upwards of $200,000. Under the Slayer statute, a person cannot receive an inheritance from the death of someone they intentionally killed. As Reiner's legal fees pile up, his attorneys argue he has not been convicted of killing anyone, just accused. Is that a strong enough case in your view?
There's definitely an argument to be made, but there's a stronger argument that's sort of being lost here, and that is that under the trust, Reiner was supposed to be paid out 3 years ago, several hundreds of thousands of dollars, which had it been paid out, he could have used those for his legal fees today. He is saying that he never said that they should be kept in the trust back then. That's what the trustee is saying now. And if that's the case, then Reiner may have a really good argument that maybe I don't get the whole amount, but anything that should have been given to me 3 years ago before this death happened to my parents, that I'm entitled to and that I can use for my legal defense.
Well, Reiner's criminal trial is set to begin next month. The civil trial for the trust fund set for October. How could the dual cases impact each other?
I expect the criminal trial won't happen for quite a while. So he will have plenty of time in the civil arena to try to collect the funds needed to hire private counsel. It sounds like that's what he's trying to do. In fact, I was told that his criminal defense attorney that he's trying to retain was actually there in the civil case today in court. So it seems like those are the dots that they're trying to connect, and he may have a good shot at it.
Criminal defense attorney Lou Shapiro, always good to see you. Thanks for being with us.
You got it.
All right, thank you.
Dude, guess how much it cost me to make sure my family gets